Say heaven. Good day everyone, I'm SHERYL S. MATURAN and my co-reporter is Jella Makilang. So our report in Obligations and Contracts, Laws, Principles, and Jurisprudence is on Chapter 4, Section 5. It's all about compensation. So in Article 1 to 78, compensation shall take place when two persons and their own right are creditors and debtors of each other. So for example about this is X owe Y 20,000 pesos and Y owe X 20,000 pesos. So in this case, there is a total compensation or a compensation exists and takes place because both X and Y are principal creditors and principal debtors of each other. Thus, in Article 1 to 78 in Civil Code, compensation is said to take place when two persons in their own right are creditors and debtors of each other. Compensation is a mode of extinguishing to the concurrent amount the obligation of those persons who in their own right are reciprocally debtors and creditors of each other, and the offsetting of two obligations which are reciprocally extinguished if they are of equal value, or extinguished to the concurrent amount if of different values. So in compensation distinguished from confusion, so naay dakong kalahian kay tungod sa compensation kinahanglan both persons creditors and debtors of each other, and there must be at least two obligations, unlike sa confusion nga kinahanglan usa ra gad jud ang mamahimong creditor or debtor ana nga sitwasyon, and there is only one obligation. So mao na siya ang sa compensation og confusion. In Article 1 to 79, in order that compensation may be proper, it is necessary that 1. The parties are principal creditor and principal debtors of each other. 2. Both debts consist in a sum of money or consumable things of the same kind and quality. 3. The two debts are due or demandable. 4. Two debts are liquidated. 5. No retention or controversy has been commenced by third person. So in number 1, the parties are principal creditor and principal debtors of each other. So for example, A owes B 100,000 and B owes A 100,000. Therefore, compensation will take place because A and B are both principal debtors and creditors of each other. So in number 2, both debts consist in a sum of money or consumable things of the same kind and quality. So for example, A owes B any horse and B owes A any horse. So the compensation will take place on this case, although the things due are not consumable, since the things due are on the same kind and quality. So for number 3, the two debts are due or demandable. For example, A owes B 10,000 pesos due today, and B owes A 10,000 pesos due today. So compensation takes place because both debts are due on the same time and date. So for number 4, two debts are liquidated. For example, A owes B 10,000 pesos and B owes A the share of the latter in the business, the amount of which it's already liquidated as 10,000 pesos. Therefore, compensation takes place because both debts are liquidated. So for number 5, no retention or controversy has been commenced by third person. So this is a negative requisite for legal compensation. The other such requisite is that the compensation is not prohibited by the law. In Article 1280, notwithstanding the provision of the preceding article, the guarantor may set up compensation as regards what the creditor may owe the principal debtor. So, this article is an exception to the general rule that only the principal debtor can set up against his creditor what the latter owes him. So, in right of the guarantor to set up compensation, the guarantor may set up compensation as regard what the creditor may owe the principal debtor. Although the guarantor is only subsidiarily, not principally bound, he is given the right to set up compensation. The reason is that the extinguishment of the principal obligation as a consequence of compensation carries with the accessory obligation of such a guarantee. As an additional information, so there are kinds of compensation as to cause and as to effect. So for as to cause, there are 4 subordinates or types: legal, voluntary or conventional, judicial, and facultative. So for as to effect, there are only 2: total and partial. So in Article 1281, compensation may be total or partial. When the two debts are of the same amount, there is a total compensation. So kinds of compensation as to effect: total, when the two debts are of the same amount; partial, when the two debts are not on the same amount. So for example of the total compensation, A owes B 10,000 pesos and B owes A 10,000 pesos. So therefore, there is a total compensation exists or takes place with that case because both A and B owes each other with having an exact and the same amount. So while the partial, for example, A owes B 5,000 pesos and B owes A 10,000 pesos. So therefore, there is no total compensation exists because A owes B only 5,000, but B owes A 10,000 pesos. So there is a partial compensation exists because there is no exact and there is no having same amount as both of them owes each other. So in Article 1281, in this statement, total or partial compensation applies to all different kinds of compensation. So total compensation results when the two debts are of the same amount. If they are of different amounts, compensation is total as regards the small debts and partial only with respect to the larger debt. So, mao to ang kalahian sa total og partial. Kinahanglan total same amount, while partial dili siya same amount. That's all. So in Article 1282, the parties may agree upon the compensation of debts which are not yet due. So this provision of law is an exception to the general rule that only debts which are due and demandable can be compensated. So conventional or voluntary compensation are pertains with this article. So, conventional or voluntary compensation which occurs when the parties agree to the mutual extinguishment of their credits or to compensate their mutual obligations even in the absence of some of the legal requisites. um, Requisites of conventional compensation. One, that each of the parties can dispose of the credits he seeks to compensate, and two, that they agree to the mutual extinguishment of their credits. In Article 1283, if one of the parties to a suit over an obligation has a claim for damages against the other, the former may set it off by proving his right to said damages and the amount thereof. So, this article refers to judicial compensation. Compensation may also take place when so declared by a final judgment of a court in a suit. A party may set off his claim for damages against his obligations to the other party by proving his right to said damages and the amount thereof. So in Article 1284, when one or both debts are rescissible or voidable, they may be compensated against each other before they are judicially rescinded or avoided. So this article should be correlated with Article 1381 and 1390. So compensation of rescissible or voidable debts. Rescissible at 1381, Article 1381, and voidable obligation at Article 1390 are valid until they are judicially rescinded or avoided. Prior to rescission or annulment, the debts may be compensated against each other. So example of this article are um, A owes B 10,000 pesos. Subsequently, A, through fraud, was able to make B sign a promissory note that B is indebted to A for the same amount. The debt of A is valid, but B is voidable. Before the debt of B is nullified, both debts may be compensated against each other if all the requisites for legal compensation are present. Suppose B's suppose B's debt is later on annulled by the court. So, is A still liable considering the compensation had already taken place? Yes. The effect of the annulment is retroactive. It is the same as if there had no compensation. So note that rescissible as well as voidable obligations are valid obligations. Therefore, they may be compensated against each other before they are judicially rescinded or avoided. That's all.
Article 1285. The debtor who has consented to the assignment of rights made by a creditor in favor of a third person cannot set up against the assignee the compensation which would not pertain to him against the assignor unless the assignor was notified by the debtor at the time he gave his consent that he reserved his right to the compensation. If a creditor communicated the cession to him but the debtor did not consent thereto, the latter may set up at the compensation of debts previous to the cession but not the subsequent ones. If the assignment is made up without the knowledge of the debtor, he may set up the compensation of all credits prior to the same, and also later ones until he had knowledge of the assignment, where compensation has taken place before assignment. Example, A owes B 3,000 pesos due yesterday. B owes A 1,000 pesos due also yesterday. Both debts are extinguished up to the amount of 1,000 pesos, hence A still owes B 2,000 pesos today. Now, if B assigns his right to C, the latter can collect only 2,000 pesos from A. However, if A gave his consent to the assignment before it was made or subsequently, A loses the right to set up the defense of compensation, so A will be liable to C for 3,000 pesos but he can still collect the 1,000 pesos owed by B. In other words, the compensation shall be deemed not to have taken place. Where compensation has taken place after assignment. Article 1285 speaks of three cases of compensation which take place after an assignment of rights made by the creditor. One, where the assignment is made with the consent of the debtor. Another one in which the assignment is made without the consent but with the knowledge of the debtor. And the third is one that which the assignment without the knowledge of the debtor. Article 1286. Compensation takes place by operation of law, even though the debts may be payable at different places, but there shall be an indemnity for the expenses of exchange of transportation to the place of payment. This article applies that legal compensation, the indemnity contemplated above does not refer to the difference in the value of the things in the respective places, but the expenses of monetary exchange in case of money debts and expenses of transportation in case of things to be delivered. Once these expenses are liquidated, the debts also become compensable. The indemnity shall be paid by the person who raises the defense of compensation. Example number 1. A owes B $1,000 payable in New York. B owes A 28,000 pesos equivalent amount payable in Manila. If A claims compensation, he must pay for the expenses of exchange. Example number 2. A obliged himself to deliver to B 100 sacks of rice in Davao. B is also bound to deliver to A 100 sacks of rice of the same kind in Bulacan. The expenses for transportation of the rice to Davao amount to 4,000 pesos and to Bulacan 1,000 pesos. If A claims compensation, he must indemnify B to the amount of 3,000 pesos for the expenses of the transportation of the rice to Davao. Article 1287. Compensation shall not be proper when one of the debts arises from a depositum or from the obligations of depository or a valet of accommodatum. Neither can be compensation be set up against a creditor who has a claim for support due by gratuitous life, without prejudice to the provision of a paragraph 2 of Article 301. Article 1288. Neither shall there be compensation if one of the debts consists in civil liability arising from a penal offense. So, there are 4 instances when legal compensation not allowed by law. First, where one of the debts arises from a depositum. A deposit constituted from the moment a person receives a thing belonging to another with the obligation of safety keeping it and returning to the same. Article 1287 uses the word depositum instead of deposit, which is used for an ordinary bank deposit. So, bank deposit is not a depositum. It is really a loan which creates the relationship of debtor and creditor. Similarly, a depositor has very right to set off his money deposit with a bank against the loans he had obtained from his said bank. The second instances of legal compensation are not allowed by law, where one of the debts arises from accommodatum. So, Comodatum is a gratuitous contract whereby one of the parties delivers to another something not consumable so that the latter may use the same for a certain time and return it. The third instance is of legal compensation not allowed by law, where one of the debts arises from a claim for support due to by gratuitous title. So, support comprises everything that is indispensable for sustenance, dwelling, clothing, medical attendance, education, and transportation in keeping with the financial capacity of the family. The last instances of legal compensation not allowed by law is where one of the debts consists in civil liability arising from a penal offense. So, if one of the debts consists in civil liability arising from a criminal offense, compensation would be improper and inadvisable because of satisfaction of such obligation is imperative. Article 1289. If a person should have against him several debts which are susceptible of compensation, the rules on the application of payment shall apply to the order of compensation. Rules on application of payments applicable to order of compensation. Compensation is similar to payment. If a debtor has various debts which are susceptible of compensation, he must inform the creditor which of them shall be the objective of compensation. In case he fails to do so, then the compensation shall be applied to the most onerous obligation. Example, A is indebted to B in the amount of 1,000 pesos without interest due today. Second, 1,000 with interest of 12% due to also today. Third, 1,000 pesos which interest of 10% due yesterday. B owes A 1,000 due today. For purposes of the application of payment, A is a debtor. He must specify to B which the three debts should be compensated. If he fails to inform B, then the latter should apply the compensation of the second obligation of A, namely, the obligation bearing the 12% interest because it is the most onerous obligation. Article 1290. When all the requisites mentioned in Article 1279 are present, compensation takes effect by operation of law and extinguishes both debts to the concurrent amount, even though the creditors and debtors are not aware of the compensation. There are two consent of parties not required in legal compensation. First, compensation occurs automatically by mere operation of law. From the moment all the requisites mentioned in Article 1279 concur, legal compensation takes place automatically, even in the absence of agreement between the parties and even against their will, and extinguishes reciprocally both debts as soon as they exist simultaneously to the amount of their respective sums. It takes place in sojourn from the day all the necessary requisites concur, without need of any conscious intent of the part of the parties and even without their knowledge at the time of the coexistence of such cross debts. Second is the full legal capacity of parties not required. As it takes place by mere operation of law and without any act of parties, it is not required that the parties have full legal capacity to give or to receive. On the other hand, in order that they may be a valid payment, the parties must have the predisposal of thing due to the capacity of alienate it and to receive it the payment. Compensation, a matter of defense. Although compensation is produced by operation of law, it is usually necessary to set it up on defense in an action demanding performance. Once proved, its effects or retroact or relate back to the very day on which all the requisites mentioned by law concurred or are fulfilled. That could be all. Thank you.